Good morning, everybody. Thank you for joining us this morning. We're excited to have Mr. Bob Bond and Mr. Chris Brown share with us today. I know that you're excited. For those joining us who don't know me, my name is Lynn Riddle, and I'm with our Stewart Title Champions location. We just moved. We are in a new office, and we're located off of Highway 249 and Cypresswood, 19450, and we are on the second floor. I've got 4 escrow officers and 4 assistants, 1 Spanish speaking. We can handle all of your closings from commercial, residential, land, new build, all of that. I work very closely with my partner, Miss Becky Bohannon, and I'll let her tell you a little bit about her branch and her location as well.
Okay, my nose is running. So my name is Becky Bohannon. I'm with the Stewart Title Office. If I don't know some of y'all, you don't know me. We are very excited to have you here. I know we have a lot of people, so I'm very excited about that. Danny's texting me. He's saying I'm too loud. So sorry, Danny. We are located in Tomball at 14080 FM 2920 off 249 and 2920. We have 2 escrow officers and 3 assistants. Obviously, we do the same as Lynn's office. We close on commercial, refis, resales, new build, all of it. So we're here for you. I think I can speak for your office too, Lynn, that we are letting people back into our office for closings. We only want the signers to come in, not the realtors, the kids, and all that. We want to keep everybody as safe as possible. So only signers. If you choose to do a mobile notary, that is all okay as well, but we are letting people back in. So if you do see our doors locked, it's not because we're closed, it's just because we're protecting everyone. So anyway, we're excited that y'all are here, and we do hope to see y'all soon. I know Lynn and I are going nuts because we want to see y'all, but most of all, we're open, we're here for you, we want to work for you. We want to support you, and if there's anything that any of y'all need, please let us know. We want to be your go-to girl.
We do. If you're closing with anybody else, then you're in the wrong place. So give us a shot. And with that, we'll let you gentlemen take it away. Becky and I, we're both very busy. Thankfully, we're blessed. We have a lot of closings going on. So I may step in and out of the picture every now and then, but I'll definitely be stepping back in. If you have a question for me or for Becky, if you'll just put it in the chat. That's probably how Chris and Bob want you to do it as well, but I'll let them kind of steer it and tell you how they want to do it. But just put any questions in the chat and we'll make sure that we'll get to it.
Perfect. Yes, that's exactly what we'd like.
That sounds great. Well, thanks, Becky and Lynn, for sponsoring us today. We're delighted to be able to talk to all these good folks. And let me move to the first slide here. So our subject today is listing homes for disabled or deceased clients. And of course, as mentioned, I'm Bob Bond. I've been practicing law here in the Greens Point area for 25 years. And Chris joined me a couple of years ago, and he's my partner. And we're kind of like you guys. We need a constant flow of clients. And in our practices, yours and mine, we get to work with a lot of dead and disabled people, or at least the people that represent those dead and disabled people. And so in that sense, we have a lot in common. Another thing that we have in common, which you might not realize, that, you know, you're in the real estate business and they're real estate attorneys, and you work with real estate attorneys when you're doing closings. So how come estate planning attorneys know something about this that's of interest to you? Well, it turns out that a lot of the real estate attorneys' work is fixing the deeds that estate planning attorneys do. We do more deeds, I think, than just about anybody. And so we're intimately familiar with this whole process that involves dealing with estates and so forth. So we hope we can give you some insights today that will be useful to you. And with that, let me give you a little bit of background on me. So I'm a native Texan. I grew up in Dallas, went to Southern Methodist University, And as soon as I finished SMU, I was drafted. I went in the United States Army. I went through a officer candidate school in the infantry. And although I never intended to make the Army a career, I never got out. So I was in from 1969 until 1989. And I retired as a lieutenant colonel, infantry, regular Army. Well, I'd also always said that at some point I'm going to go back to law school. So the next month I started law school. We moved back to Texas. And 3 years later, I was an attorney. Well, I'd also passed the CPA exam. And so I ended up in Houston because I went to work for Arthur Anderson in 1992. And then 2 years later, I started my law firm. Now, when you start out a law firm, you know, there's a lot of different things you can do. One thing you can do is you can sue people. But I'd already had some practice with that as an intern in law school, and I wasn't too impressed. Now, another thing you can do if you're a lawyer is you can go into family law. But as some of you may know, family law is really about divorce law. And divorce law is, in divorce law, the people that are divorcing are very unhappy and they want their lawyer to be unhappy with them. And so I found that to be not in tune with my sunny disposition. Well, at any rate, the long and the short of it was I decided that the estate planning, helping people with wills and trusts, probate and trust administration, helping people qualify for nursing home benefits under Medicaid was a real calling. I felt like it was worthy work. Just as you help your clients, we help our clients in a positive way. And so this is our calling. We like what we do. We want it to go on into the future, and we hope we can help you. And of course, I've been, in business and work for a long time. And so anytime you have a business, you need a great succession plan. And I have a great succession plan sitting right here next to me. Let him tell you a little bit about himself.
Hi, everybody. I'm Chris Brown. I appreciate you all joining us today. And so a little bit about myself. I've been a licensed attorney since 2017. Before that, estate assets. And so I've always been involved in estate management, both professionally, but also personally. I received my law degree from the University of Houston Law Center. But before that, I worked at Lockheed Martin Aeronautics on the F-16 program. So a lot of law school students go straight from undergraduate to law school. But I spent about 3 years working in industry and learned a whole lot just about professionalism and working efficiently with people. Before that, I graduated from Texas Christian University in 2009. Go Frogs. I majored in finance and supply chain management. Now, 2009 was a terrible time to be graduating with a finance degree, so that's why I ended up working at Lockheed. One more thing about me, going further back, is that a point of continuity through my whole life, or at least my adult life, has been my beautiful wife, Megan. So we are high school sweethearts. We've been together since we were sophomores in high school. And we have one cool little boy. He's just about turned 9 years old this month. And he's a handful, but we love him. And so that's a little bit about me. And what I want to do real quick is just show you that I won't be able to show you, but I can hopefully describe it to you well. So I'm likely appearing in one small box in your corner. I just want to make you aware that you can change the size of that box just like you would change the size of any other screen on your, or box on your screen. So you can expand us out if you want to, so you see more of us and less of just the slideshow.
If that was desirable.
If that was desirable. Now, additionally, you should have received an email from Mary Hicks or from our firm. And in that email was a link, or in the email would include downloadable materials that are going to be useful during the presentation, and will also be great references for you to use on into the future. So I definitely advise you to open those up and check those out. Now, at the end of the presentation, we'll talk about how you get your CE credit. So we will be sure to go over that. So we're going to have 4 parts to our presentation today. The first is going to just talk about what is estate planning and why does it affect you. Secondly, we're going to talk about what is it like selling the home of a person who is incapacitated. So what should you do? The third part will be selling the home of a person who has passed away. And then the fourth portion of the presentation is going to be a simple solution to a lot of these problems that we've presented to you. Now we're going to try to focus not just on estate planning and the technicalities of it, but we really want to keep a focus on how it affects you as a real estate agent. And because we want you to be able to operate efficiently and not get held up by these roadblocks that we're going to talk about. So awareness is really a big deal. All right, so part one, what is estate planning and why does it affect you? Well, estate planning has all sorts of meanings, and it covers a vast variety of topics. And I could honestly spend all day sitting here talking to you about each one. But so we're going to focus on a couple of them that are important and will affect you the most in your practice. So of course, most people think of estate planning as having a will. I mean, that's just what it typically is referred to. However, it also has to address the issues of incapacity. You know, as people live longer and longer and healthcare techniques advance, there's a greater and greater chance that you or one of your clients is going to be disabled at some point in time during their life, especially in later years. We also help prepare for long-term care. That's often another overlooked aspect of estate planning. So one of the main issues with estate planning is really just retitling the assets appropriately into the names of the beneficiaries after you pass away, or if you're disabled, who's going to be able to handle those assets. So we're talking about the house, bank accounts, investment accounts, but also vehicles and personal property, even as far down as pets. But again, you got to ask the question, this is the age-old question, how does this affect me? Well, we're going to talk about some of the specifics about estate planning and how those aspects of estate planning can affect you. But really what you should know is that this stuff is important, and it's important to have a relationship with an estate planning attorney that you can call upon when you run into these issues and you have questions or maybe even just an uneasy feeling about the situation that's been presented to you. Okay, so why would this affect you in your practice as a real estate agent? Well, first of all, just like us as attorneys, one of the very important things we have to do is define the nature of our relationship at the onset. So we offer free consultations to prospective clients who come in, but we have to make sure that that is who our client is actually going to be. So for you guys, you need to know, well, is the person who approached you actually the owner? Or is it just one of the family members, perhaps the loudest family member? And so who can discuss information with you and who can sign documents? And so this is, one more point I wanted to point out here. At the bottom of each of these slides, you'll see practice tips. And so the practice tip on this slide is you need to define at the outset of the nature of the relationship. These practice tips are going to be really helpful, so be sure to pay attention to those, please. And so again, you're going to want to know who is actually your client. And we're going to try to inject a little humor in here as well, because I know some of this stuff can be technical. So this comic says, and I'm sure I can trust you not to fight over my money when I'm gone. And they're saying, of course. You would imagine how many siblings we see in our office that do not get along with one another. I mean, it happens all the time. And so we don't want you guys also to run into these sort of conflicts. And, you need to be aware if there's multiple siblings or multiple people on the deed, that everybody gets along and is going to be willing to sell that property when you got somebody that's there to buy it. All right. And now the bottom line. So assumptions are trouble. What you don't want to do is make assumptions and then have them blow up in your face just as you're about to close, causing you delays. And as we all know, on that same note, time is money. So about assumptions, if you ask the right questions, you're making less assumptions because you're getting more information. So what we like to commonly do in our practice during our initial consultations is, when an artist uses their paintbrushes, they choose their paintbrushes carefully, they take care of them, and they use them carefully. Well, for you and for us, our questions are our paintbrushes. So that's what you use to paint a picture of what's going on. So you want to ask your questions carefully and use them appropriately. And so ask questions, and we'll talk about which questions to ask. Additionally, clients appreciate that you'll be competent in these issues. It just raises their confidence in you. They'll also appreciate that you've got a network relationship with an estate planning firm that can help them if they need it. And then lastly, don't forget about yourself. These things are just as applicable to you as they would be your clients. All right, now moving on to the second portion of the presentation. Selling the home of a person who is incapacitated. And so tell me if you ever heard this before. Mom is disabled, the house is too big for her, and she can't handle her affairs anymore. Well, that's, first of all, not how the law defines incapacity. But the good point is, you don't have to worry about delving into the complexities of what is incapacity or not. You just need to know, is there a question as to the capacity of the homeowner? And so incapacity means that the person can't manage their affairs. But what it doesn't mean is that somebody else has the authority to act for them. Incapacity just means that that person can't sign the documents. And so here's where really the rubber meets the road is, what do you do when you're selling the home of an incapacitated person? So daughter comes to you and says, Mom just can't live in the home anymore. She needs additional care and she can't handle her affairs. So I'm going to be the one working with you, the real estate agent. Okay. Well, first question you're going to ask is, so Mom's on the deed, is she able to sign documents? So if she is able to sign, then that's fantastic. But I will warn you that if it seems like the person you're speaking with has any doubts about the homeowner's ability to sign the documents, or they say that they can't, then what you want to do is ask for a statutory durable power of attorney. And if they do have a statutory durable power of attorney, then you want to make sure that they are the listed agents, that they have the original in their possession. A copy will not do. And you'll notice on the practice tip here, a statutory durable power of attorney is not the same as a healthcare power of attorney. They do completely different things. There's a lot of different types of powers of attorney out there. So just look for the correct power of attorney. It's a statutory durable power of attorney. And so if they do hand you a valid looking power of attorney, there's a couple of things you want to look for. So first is there one family member who is the agent? Or are there multiple members of the family who are named? If there's multiple people named, well, you're definitely going to want to have to look a little bit closer. And so you want to see, are they listed as co-agents? So can they all act without consent of the other? Or do they all have to agree?
Well, the title company is going to make them all agree anyway, even if they're listed as or. So the title company on a closing is going to want them both to sign.
And so you just want to be careful that you know who can act, even if there is the power of attorney document. And so there's a lot of power of attorneys out there, power of attorney documents, but I promise you they are not all the same. We run into power of attorney documents all the time that
the good, the bad, and the ugly.
Yeah, they will not accomplish or help accomplish what we want to accomplish. And so just first off, so this is a screen print from the power of attorney document that you find in the materials that you were emailed. So if you want to look, we've got an example of what a good power of attorney should look like. And so one of the first things I want to show you is just in the name, statutory durable power of attorney. So we know power of attorney means you're nominating somebody to act in your place. So let's talk about statutory. Statutory is because it references a statute. The power of attorney itself is created by a statute. Additionally, it's durable because it survives the principal's incapacity. So if you sign a normal power of attorney, you know, there's some power of attorney documents out there that are just used maybe for a transaction or for a special purpose. Well, if the principal of that power of attorney document becomes disabled, then it's no longer in effect unless it's a durable power of attorney. And then what you want to look for is, if it is a statutory durable power of attorney, you want to make sure that, well, it's got the powers that you need to do what you want to accomplish, which is sell the home, right? And so you want to look, does it specifically mention a power to transact real estate? And even if it does, be careful. It's going to be reviewed carefully by title attorneys, and there are a lot of rules here in Texas. And so sometimes you'll see a power of attorney document that essentially says, my agent is to have every power that I have. That sounds great, right? I mean, it's all encompassing, so no problems. Well, that sounds great, but it's not. It's wrong. And the reason for that is the financial institutions, the title attorneys, whoever's looking at this power of attorney and going to be putting their stamp of approval on it is going to want some specificity. They're going to want some details about what powers are actually included. And so this is another screen print from the power of attorney document that you have in your materials. And so you'll see that it says, I grant my designated agent the power to act in any lawful way with respect to all of the following powers. And the first one listed there is real property transactions. So that's great. It doesn't tell you a whole heck of a lot though. Real property transactions, that's not very specific. Well, if you look down at the bottom, it says these powers are more fully described in the Texas State Codes section 752.101 to 752.1145. That's where the specificity comes in. So just saying to be able to transact real estate isn't enough, but with that reference, there's pages of it. This is just a small portion of what the Estates Code says about the power to transact property. And so this is really what the financial institutions and title attorneys are going to look for. Now, title companies will accept POAs, but you should be aware that they're treated with precaution. Title attorneys are leery of power of attorney documents because fraud is rampant with power of attorney documents. It's easy to commit fraud with a power of attorney, so they have to be very careful with them. And so some of the things that you'll have to be aware of is that they won't accept it if it's not properly notarized. It also has to be the original copy. It can't be a duplicate. It has to specifically authorize the sale of property, just like we discussed. And then the principal has to be alive, and you might actually have to prove that. So once a person passes away, that power of attorney document is no longer effective. It has no power. Just like a will has no power until somebody passes away. So your power of attorney is your disability planning document. Now, it's not the best disability planning, but it's a start. And so all of these are issues that you're going to want to be able to identify and discover prior to going to closing. So title companies, like I said, they accept the POA, but you yourself can ask a couple of quick questions of reviewing the document and have an idea on how this thing is going to play out well in advance of a title attorney looking at it. And so first thing you want to look at is the signature legible. If it just looks like chicken scratch, it's going to be highly questioned by the title attorney. Because oftentimes people who are disabled, well, that's what their signatures look like. Does it list the powers needed? So we just talked about that, what to look for. When was it executed? This is a big one. Now, very old power of attorney documents are treated more with more skepticism. And the reason for that is, well, the institution or the title attorney don't know whether or not there's been a new power of attorney done more recently that would have revoked the old one. And then lastly, are there any conflicts of interest? You know, these conflicts of interest do arise. It won't invalidate using a power of attorney, but it will definitely raise some eyebrows and probably create additional requests for information. But either way, if you have any doubt about the power of attorney that you're looking at or any estate planning issues, give us a call. This is what we do every day. And so, you know, we can help you out. And that's what we pride ourselves in, is being here to help out people with their estate planning and being trusted advisors. Bob, how about you run us through a couple of scenarios?
All righty. So do you know how powers of attorney work? So first thing, we've got person comes in to see you and she wants to use her mother's power of attorney at the closing. She also mentioned that her mother passed away last week. Is this a problem? Well, this is a little quick review because we just pointed out no power of attorney is any good once someone passes away, period, end of subject. And you say, well, doesn't everybody know that, or is this really a problem? Believe me, we encounter this quite frequently. People don't understand that at all. They say, well, mom died, but I can sell the house. I've got power of attorney, as if that solved the problem. Well, it doesn't solve the problem. Once someone's passed away, the power of attorney is over, finished, void, done for. And it's not one of these deals where they're going to be able to put one past somebody. The people that run financial institutions and title companies know this full well, period. So your prospect shows you a power of attorney that she's planning to use to sell mom's home and ask your advice. Okay, so as kind of a review, we need our common sense review of the form. So is the prospect that you're going to work with, are they the ones named as the agent? If they're named as co-agent with someone else, then you might want to ask if they're on good terms and on the same sheet of music about selling the property. If they're not on the same terms, then this is going to be a problem. It's going to slow things down. Like we said, we want to make sure it's got real estate powers. Now, not all powers of attorney are statutory powers of attorney that refer to a statute. And so you can still have a valid power of attorney as long as it's set up, it names the agent, and it's signed and notarized, and it has specific statement about the powers that are being given with regard to selling real estate. So we encounter those. Another question that comes up is, what if the person has a power of attorney from another state? Is it not valid if it's not a Texas statutory durable power of attorney? That should not be a problem as long as that power of attorney was valid under the law of some state and is specific enough and is signed and notarized and you can get an original of it. Then you can use it even though it was done in a different state. Do the powers need to be initialed in order to be effective? Now, this is another part of your common sense review. You'd be surprised at how many times we see these statutory durable powers of attorney, and there's different formats for these. Some of these formats require that the person initial in front of each power they're giving, or initial someplace to indicate that they're giving all the powers. You'd be surprised how often we see these and they haven't been initialed.
Happens.
So this is not going to work. Very frequently, the agent's got a copy, and so the hitch is that in order to transfer real estate in Texas, you have to file the power of attorney, and you cannot file a copy. So somebody's got to be able, the agent, the person you're working with has got to be able to find that original power of attorney. Now, you say, well, why aren't they all filed to begin with? Well, they don't have to be filed to be effective in other contexts. So to use one at a bank, you don't need to have it filed. So it's very frequent that they're not filed. The other reason is that somebody might later change it. So it's fairly unusual to see a power of attorney that's already been filed. But again, in your quick examination of this document, if it's been stamped and it's already been filed, well, even if the agent's even if the person you're talking with has got a copy, if it's been filed in the deed records of Harris County and that's where you're trying to sell it, you're good to go. Okay, and but anyway, some things to consider. Okay, then this issue about the signature. So the signature doesn't have, I mean, my signature is not all that legible. That's not really what we're talking about. What we're talking about is that in our practice, at least, in dealing with a lot of elderly people, sometimes we see signatures that are extremely poor or scrawled or not on the lines. And it raises an immediate question about whether the person had enough capacity to sign that. Well, that's going to make the sale of the house difficult. Let me put it that way.
Sometimes you can tell that it was done by a very, very shaky hand.
Now, if a person, don't get me wrong, if someone has special needs, but they have their mental capacity, or if they had some sort of palsy or paralysis, but they have mental capacity, they can legally sign or give assent to create a power of attorney. But what I'm talking about is a standard power of attorney with an extremely poor signature that raises questions. And it doesn't hurt to look at the notary. Sometimes they just are done by somebody that doesn't do notaries very often, and this can raise issues. All right, Chris, tell us what to do if we haven't got a power of attorney.
All right. Well, there is no power of attorney. So let's say daughter approaches you and she wants to sell mom's home, but she does not have power of attorney and mom is incapacitated. What do you do? Well, it's not an easy road, I'll tell you that.
The short answer is you're fresh out of luck, but we're going to go into a little more detail.
Yeah, we'll go over this briefly, but because either way, it is a very difficult situation. So what has to happen is that a guardian is going to have to be named, in this case, the daughter. But it's going to be a court process to have that happen. So living probate, probate is typically what you think of when somebody passes away. You know, you go to probate court. Well, probate also handles living probates, which is naming guardians. And that is a very long and drawn out process for as long as the disabled individual survives. So what happens in a living probate is that a guardian is appointed and the guardian will assume legal responsibility for the other person's affairs. And so they're going to have financial and healthcare control. Now, the main point is you want to help, or let's say daughter wants to really help out mom. There's no ill intentions or anything, but these are precautions that have to be put in place so that disabled individuals are protected. You might think to yourself, well, you know, this all seems pretty legit and straightforward, so I'm just going to have the sales document signed anyway. Well, that's a bad idea. You want to follow these procedures. And I think the most important reason is, first of all, you're going to have multiple parties inspecting these documents. But additionally, you don't want to be complacent in or participate in fraud. Now, there are ways to avoid these issues and a much better system of planning, and we'll talk about that in a little bit. But just know that if there was a trust, it would work a little bit better than with a power of attorney. In fact, significantly better, because you're not going to run into some of these roadblocks. Before we get there, we're going to talk about some of the different estate plans that you may run into in your practice. So we're going to talk about selling the home of a person who has passed away. Now again, people usually think of the last will and testament as being the estate plan. Well, there are many types of estate plans, and so we're going to discuss several of those. And the first one is actually the most common. And so the most common plan is to die without a plan, and that's called dying intestate. And there were recent studies done by caring.com and AARP, both said about the same thing. About 60% of Americans don't have any estate planning. And half of those people, the only reason that they don't have it is because they haven't gotten around to it. They've been procrastinating. And so it's very common to have Americans die without a will or a trust. And what happens in that case is that the laws of intestacy apply. It's the state laws of where the property should go to try to get it to the people closest to you or your client. When there are assets and somebody passes away without a will, a probate is likely going to be required. And we'll talk more about probate in a minute. The next is a will. Now, it's formally called a last will and testament, and it's essentially a safety net. It's there to provide a set of instructions of where the assets should go and who should administer the estate. But a will does guarantee a probate. Now, there's a lot of misconception about this that, let's say you've got mom's will and mom has just passed away. You can't take that will to the bank and expect the bank to do anything with it. The bank's going to want to see something from the court giving it a judge's approval, and that is the probate process. Then the bank is going to know, okay, this is legitimate. I've gotten a court, or somebody in the court system has approved this, and I'm going to go ahead and approve this transaction. And as we discussed earlier, a will only kicks in after death, so it doesn't do any planning for disability. Now, if there is a will, you're going to want to look at it way before you get to that stage of closing. Make sure everything's lined up appropriately. Now, the next option is trust. You might see trust planning as you're selling homes. Now, typically it's referred to as a revocable living trust, and that's a trust that's set up during the client's lifetime. It's like a will, but it's much more comprehensive. And so it allows you, first of all, to avoid probate. And we'll talk about why that's important and why you want to avoid probate, but that's a big deal. And it'll be much easier also for you to navigate as a real estate agent, because you're going to have just an actual list of instructions for who's going to be next, who's going to have authority. If somebody becomes disabled, if somebody passes away, who's going to be able to sell the home? You're going to know who you need to work with. And so that's a great reason for recommending a trust. You might run into transfer on death deeds. So there's two different types of transfer on death deeds. First, the transfer on death deed, but then there's also a revocable general warranty deed, which is sometimes referred to, in fact, oftentimes referred to as a ladybird deed. Now, both of these deeds accomplish essentially the same thing. When the grantor of the ladybird deed passes away, the grantee then gets possession of the home after filing an affidavit of death and the death certificate. So it's an easy way of avoiding probate and transferring the home after death. Now, transfer on death deeds and ladybird deeds, there are differences between the two. So I would advise you to give us a call to see which one would be best to use in your situation. Oftentimes we use the ladybird deed. It's better established in Texas, and well, you don't want to be a cowboy when it comes to title work. The next thing you might run into is an affidavit of heirship. And what I want to point out is that an affidavit of heirship is not a plan. It's just something that we do reactively if we can to avoid probate. And so what happens is we file the affidavit of heirship in the county records to show a transfer of ownership to the intestate beneficiaries. So let's say mom and dad have two kids, dad passes away and then mom passes away. Both kids are of the marriage. The kids are supposed to inherit the property. This is an easy, simple example of how it should flow to the kids so we can file the affidavit. It cannot be used all the time at all. There's a lot of difficulties that you might run into. First of all, complicated family structures pretty much count out an affidavit of heirship. Additionally, if there's a significant debt on the property or on the estate, then an affidavit of heirship is probably not going to be the best option. It only works for real property transactions and in limited circumstances, like I just described. One more issue with an affidavit of heirship is going to be that, let's say son and daughter inherit the property using an affidavit of heirship. Well, they're both owners on that property now. Well, let's say maybe it was 4 kids or 5 kids. The more parties there are, the more problems that are likely to arise because they all have to agree on the sale. They're all owners. And so another thing just to be aware of. But it is, I do want to point out, we're always looking to save our clients as much money as possible. It's really and do the job effectively, of course. So it's really our duty to do that. And so whenever we can do an affidavit of heirship, we will. We don't want to have people go into a probate court and through a lengthy and expensive probate when they don't need to. So we will use an affidavit of heirship if we can, but it's not something that we plan. It's not a plan that's put forth in advance. It's just a good alternative. Now, one of the favorite things that many other attorneys, actually not us, would like to see is do-it-yourself documents. And why is that? Because they're often riddled with inconsistencies and messes that need to be cleaned up. And that's where some attorneys make most of their money. And so we want it to be stressed that these documents and the quality of the documents is extremely important. But even more important is the relationship that we develop with our attorneys, with our clients, who would also potentially be your clients. And so having good advice and having a trusted advisor is extremely important to actually just know what you're doing.
Also, we can help. A lot of times the problem is getting when you're working with a prospect or client to sell the home, you don't want them to get stalled. And a lot of times if they're not sure what to do, or they have their own little notion about how they're going to handle it, and that notion's not correct, it just slows down the process. So in some cases that you're going to encounter, it's going to be helpful to have them talk to us, because we'll clarify the situation, make it clear what they need to do, and get them on their way so you can complete the transaction. And our goal, of course, when you refer a client, is we want to reinforce your relationship as well. So it's good for the clients, and it's good for your business, and it's a good way to help folks.
Absolutely. All right, so here again, where the rubber meets the road. So it's time to actually sell the home of a deceased individual. So how does that actually work? And so we're going to inject a little humor in here. I thought this was great. I laughed for probably about an hour after I read this the first time. Did you know the word homeowner has the word meow in it? Good luck ever pronouncing it correctly ever again. Homeowner.
Homeowner.
All right, so tell me if you heard this one before. You're close to closing, and I tell you what, if you practice as a real estate agent long enough, you're going to run into these sort of situations.
Or probably have already run into it many times. So this is a lesson we keep learning.
Is that so you're at the closing, and you're close to being done and really making your commission, and the title company asks for the documents related to the estate, and neither you nor the family has these documents. Now the closing gets delayed. That's not a good thing. Just like you, here in our practice, we have to focus on providing quality services to our clients, but we also have to run an efficient business, and delays cost time, so they cost money.
And frustration.
And
unhappy
frustration.
clients.
Unhappy real estate agents, unhappy attorneys. You want an efficient process, and so you're going to want to look for these things in advance. So for most estate plans, like I said, most estate plans are not having a plan at all. And that's almost always going to require, if there are probate assets, it's going to require a probate. And then we discussed earlier that if you have a will, it's going to require a probate, and for a probate judge to approve that will before it has really an effect. And so what you want Well, let's talk about probate a little bit first and talk about what it is and why it's
Well,
important.
Chris, on that last slide, you said if they don't have a will, it's just more trouble. That doesn't mean you get to dodge probate.
Yeah, no,
It just makes the probate a lot more trouble. It makes it more expensive and take longer. So not having a will is not a great solution.
It is
to
not
this
a great
problem.
solution. That's a great point, Bob. So your will is going to tell the court who your executor is going to be, who you want your assets to go to. You have some control there, right? And there's instructions. Well, if you don't have a will, it gets a lot more complicated because the court is going to be in complete control. They're going to appoint an executor, not who you choose. They're going to decide where the assets go.
Just for example, if the will is properly done, the executor, once they're appointed, has the power to sell the real estate right out of because of what the will says. If the will is somebody writes up their own will, or the will's fill in the blank deal, and it doesn't have real estate powers in the given to the executor in the will itself, then the executor is going to have to go back to the court and get an order authorizing the sale of the house. Are we having fun yet? This is just adding another wrinkle to this. And that's also happens with the guardianships. Once the guardianship's established, the guardian's got control of everything, except they got to go back to the judge and get the judge to approve big transactions like the sale of a home. So at any rate, good planning would certainly makes your life a lot simpler than bad planning.
Yeah, and if you're selling the home of somebody who's passed away, you're going to much rather that they had a will and to make that whole probate process go by quicker. And so death probate, the main purpose of death probate is to retitle the assets. Now, if there's minor children, it also involves making sure that there are guardians set up for those children. But retitling the assets after you die is the main purpose of probate. And so it gives legal authority to your executor or the executor of your clients to actually sell or transfer the property, just like what Bob was just referring to. Now, the court is going to overview the whole process. Again, back to Bob's point, if there was no will, they're going to keep a much closer eye on everything, just like selling a piece of real estate. So it seems easy, but it's really not. You want to avoid it. And the reason for that is it's not a quick process. Now, it's quicker here in Texas than it is in some states, but it's still a burden. Also, it can be expensive, and you can expect at least a 2-month delay, really. And so what happens is the probate judge, after we go into the probate hearing and submit the will for review, they will give what's called letters testamentary. And those letters testamentary are what you or your client will take to the bank, to the financial institution, or provide to the title attorney to be able to show that you have authority to sell the property. Well, it's going to take time to get those letters testamentary. One reason that a lot of people really dislike probate is that it's an open court process. So it's open to public records. And so all of the assets, the inventory of the assets, who they're going to, who's in charge, that's all going to be public record, available for anybody that wants to look it up. And then if there are, let's say the home's here in Texas, but there's a vacation home, Colorado or something, they're going to have to likely do another probate or something similar in both states. And that's just a huge burden if there's properties in other states. And the practice tip here is a big one. If you're selling the home of a deceased person, and if there's a will or no will, if there's going to be a probate, you want that to get initiated as soon as possible. Because let's say there's that 2-month delay. Well, you don't want that 2 months to start once you've already gotten a buyer lined up. You want that to start now, so you're not delayed at the time of closing. And to talk about expenses, and so in our office, just a bare bones probate costs $3,500. And that's with a will. Now, it can go up to $7,000 if there's no will, because like we said, there's a lot more involved with that. So we have to charge more for it. It says there, lawyers love probate because of the extraordinary fees. Just going to court, it's just a long process and it makes a lot of work. And so You want the family to be able to avoid that, either your family or your clients. All right, so like we said, if you practiced for a while, you probably already run into these things, or if you are just beginning, you probably will run into these things. So again, be alert and ask the right questions. Use those questions and don't rely on your assumptions about what's going on. Don't wait to act, because if you do, you'll likely face delays later on. And if you have any questions or a client with any questions, just have them give us a call, or you give us a call. We're here to help. All right. Bob's going to run us through a few more scenarios.
All right. Do you know how a last will and testament works? So the seller has mom's will. The document looks very official. It's initialed on every page. It's signed. It's witnessed. It's notarized. It's on fancy paper. And the seller is clearly designated, the person you're talking to is clearly designated as the executor on this document. It says in plain English that she or he is the executor. And so the seller says, when you mention that the need for probate, or ask them if they have started the probate action, the seller says, I don't see why I need to go to court. It's perfectly clear that I can sell the home. And you say, is this going to happen to me? Does this happen very often? You bet. Okay. A lot of people think that because it's a form of wishful thinking. I don't think their attorney told them, or whatever they read when they were, or whoever they talked to when they were creating their will told them this. But after the fact, they decide that since the will is clear on these points, it must mean since they have a will, they don't have to go to court because they have this official document. Well, that official document is not going to do them any good in selling that house or transferring a financial asset until they go to probate court. Okay, so your client needs to understand that early on, and that 8-week process that Chris was talking about, it can't begin until they go see an attorney, do an application for probate. We got to submit the application and the original last will and testament to the court to start the 8-week process. So you don't want that client wandering around thinking that they don't have to go to probate for another 2 or 3 or 4 weeks or longer before they decide to do something about it. And so we can reinforce when you tell them, hey, you're going to have to do this. So your question might be, well, wait a minute. Tell me, why won't they accept this thing if it's all fancy and it looks so complete? The reason is that the financial institution and the title company do not know if that is the decedent's original last will and testament. In other words, the person may have executed wills later. And the person you're talking to might be the first wife who's trying to make an end run around the current wife and family. Well, the title company and the financial institution are not going there. It could be a forgery. They don't know. They're not going there. The system is clear to these financial institutions and title companies. If probate needs to be done, they want letters testamentary, a letter from the judge saying the person is authorized to sell it. So you want to get that thing. You want to get this clear and get them going as quick as possible. Okay, receive a call from a prospective seller wanting to sell her recently deceased mother's home. When you meet, she shows you a deed with both mom and dad listed as the grantees. She tells you dad died years ago and they thought mom automatically owned it. Is she right? Well, you guys know that you probably have a joint, if you're married, you have a joint account with your wife, and you know that if you pass away, that account's going to belong to your spouse, right? It's joint tenants with right of survivorship. This is a distinct legal thing. It's authorized by law and statute. It's with respect to financial accounts, it works all across the country. However, the fact that two people's names are on an account or on a deed does not make it automatically joint tenancy with right of survivorship. Now, in Texas, there are very few deeds that you're going to see that are in joint tenancy with right of survivorship. So, when dad died, the way the Texas law looks at it, is dad owned, if it was community property, dad owned half that property. And the question is, where did it go? He could have left it to his spouse, and he could have left it to his kids or whoever, his mistress. He could have done anything with it. And so there's a big question mark about what happened to dad's interest because the will was never probated or no action was taken. So we have two problems. We may need to probate mom's will if we're not going to do an affidavit, and we've got to also resolve what happened to dad's interest. And depending on the circumstances, we may be able to use an affidavit, or we may have to probate it. So the point is, if you see a deed with two people's names on it in Texas, likely we got to resolve both of them. It's not joint tenancy with right of survivorship. And so again, your client needs to understand the problem and the need for probate for mom, and then to resolve this other issue and get all this done as quickly as possible. Okay, a probate or an affidavit of heirship is needed. When questions arise, call us. Let me talk about just for a second about affidavit of heirship. Is there another slide on here? Let me see. So let me just amplify a couple of things. Chris talked about affidavit of heirship pretty well, and he said that we use it when we can. It works only for Texas real estate. It won't work for a bank account or a financial bank account. And the property goes to whoever would have gotten it under Texas intestacy law. So, and when we can use it, it's less expensive than a probate and quicker, as it turns out. And if you've been working with title companies a long time, sometimes the title companies do the affidavit of heirship in certain cases. So you say, well, why aren't we using this all the time? What's the problem? Well, let me give you an example. Let's say that the dad dies, and his will leaves everything to his wife, and his wife is his second wife, okay? But dad had children from his first marriage. Remember, the will leaves, after dad remarried, the husband remarried, he did a new will, and he left everything to his new spouse because she needed the support, and that's the way they wanted to set it up. So that's what his will says. If we use the affidavit, the property wouldn't go to her. It would go to his children from the first marriage. His half interest would be owned by them. She would own her half interest. If we probate the will, she gets the whole house. In other words, the will gives his interest to her, and she owns the whole house. So there's an example of where this client is definitely, I would think, in almost all cases, going to want to probate the will so she has full control of the house. Usually the partial ownership by the stepmother and the stepchildren is not a happy relationship. Anyway, that's to give you a little bit of insight into affidavits of heirship. Okay, do you know how transfer on death deeds work? So let's talk about that for a second. She tells you that her mom died and asks you to look at the deed that gives mom's home to her. So we're talking about a ladybird deed. So what is a ladybird deed? It's a life estate deed. Well, what's a life estate deed? A life estate deed is where somebody keeps the current interest, keeps the right to use the house as long as they're alive. And the deed says, well, when I die, though, I'm giving it to you. Okay? And if you do a life estate deed, it creates an immediate transfer of the remainder interest. Well, that has gift connotations, and it also ties the property up because the remainder interest owner has a vested interest in the remainder interest. So the ladybird deed is a life estate deed with a big difference. It says that the grantor, the person that owns a home, is not only keeping a life estate and they're giving it to their daughter or children, however it says, whatever it says, but it also says that mom can change her mind and leave it to somebody else or revoke it. And so it's a revocable a deed that has a revocable remainder interest. And so this is very desirable when we're doing Medicaid planning. It avoids probate, so that is a desirable feature of it. And it doesn't tie mom's hands when she does this, and it doesn't create a gift at the time she signs the deed. So it's got a lot of potential uses and advantages. Now, once mom passes away, then the property belongs to whoever says gets it. Okay, and so we need to file an affidavit of death in the deed records to show that the grantor passed away, and now it belongs to the grantees. Now, here's the problem. The title company is going to look askance at this thing if the beneficiaries who would inherit under the rules for intestacy are not the same as the people on that Ladybird deed. Okay. So in other words, if mom had let's say she had three daughters and she passes away, and her and dad had already passed away, so she just had the three daughters. And those three daughters are the intestate heirs. If only one daughter got this, the title company is going to say, wait a minute, I wonder if there's something going on here. I wonder if this is somebody's going to raise a question about it. And it may be that the title company will want the other daughters to sign off on the closing. So you need to be attentive if the Ladybird deed doesn't go to all the kids, is the takeaway there. Also, if the Ladybird deed is done by a power of attorney and goes to one person, that's going to raise all kinds of flags. So you may have trouble with that one. And you need to talk with the title people early on, or talk with us early on about that. May need to have some other plan. All right. Tax issues, okay? A couple of things on tax issues just to kind of crystallize our understanding of this. If you sell a disabled person's home, there's not going to be any capital gains issue because they've got, or in most cases, because that disabled person, or if it's a couple, disabled person has a $250,000 exemption from capital gain on the sale of their domicile. Or if it's a married couple, they have a $500,000 exemption from capital gain. So capital gain is not going to be a problem there. On the other hand, if that home or that real estate is not their domicile, and you sell a disabled person's home, then whatever their basis is, whatever they paid for that house plus any improvements, that's going to be the basis on the sale. And so if the value of the home is in excess of that, there's going to be capital gains when that home is sold by this disabled person. Okay? If they died with it, then the house would step up in basis. Remember, when someone passes away, it erases the capital gain, and the new basis when you sell it is whatever the date of death value is. So let's say mom she owned the house, and it was she bought it years ago. She didn't pay very much for it, and then she was in one of those gentrified neighborhoods, and the price jumps way up, and so there's this huge embedded capital gains in there. Well, if she dies owning that property, the new basis is going to be the current value of it. And so when the executor or trustee or whoever sells the home, then there's not going to be any capital gains, or not any capital gains to speak of, because the basis and the value are the same. So this is an example of an advantage one of the big advantages, if there are, of dying with appreciated property is you get to step up in basis. Okay, this also comes into play when people talk about gifting property where mom or dad, and you see this all the time, the elderly mom or dad says, I want to go ahead and gift this to my kids. I was thinking maybe that would help in case I need nursing home care and I can't manage it anymore, and I'd love to do this while I'm alive. Well, one of the considerations is certainly about whether or not there's a big capital gain that they're going to be given to their kids, and it would be better to just hold the property until the parents pass away. Okay, so that gives you a little bit of idea about capital gains and step up and basis. So with that, let me get back to Chris. How are we doing on time, Chris?
It is 11:07, so we'll go fairly quickly so we have plenty of time for questions. All right, so part 4 of the presentation is a simple solution to these problems we've discussed. And the simple solution is using a trust, specifically a revocable living trust. And the easiest way, there's a lot of misunderstandings about what a trust is. For example, a lot of people think you have to be just filthy rich to have one. So let's just talk about what a trust is, and we'll use the analogy of a treasure chest. So it's really just an empty box. It's a contract that you make with yourself and with your trustees. And that box is going to hold all of you or your client's assets. And the box will include instructions on who can manage the assets, where do they go, and you can also provide special incentives or rewards, or also restrictions if you're concerned about, let's say, addiction or special needs, education. And so it provides the trustee with the ability to manage, transfer, and sell the assets. But a treasure chest without anything in it isn't nearly exciting as a treasure chest that's full of treasure, right? And so what we need to do is put your assets in the name of the trust, and we call that funding. Funding is extremely important because that's how a trust has its power. A trust only has power over assets that are titled in the name of the trust. And so it's very important to get all of your assets in there properly, and it's where a lot of trusts go wrong. A lot of trust planning goes wrong, is that assets are left out. Either they're never funded into the trust, or they're acquired after the fact and not appropriately funded at that point in time. And so it's something that we pride ourselves in, is addressing the needs for funding and the whole process. Now with a trust, this is just a little bit of overview. So you've got 3 positions. Always there's a trustor. That's the person who creates the trust and transfers his or her assets in it. You've got the trustee. Essentially, that's the person who manages it. It's the person with the checkbook. And then lastly, there's the beneficiary, who of course benefits from the assets in the trust. Now the good thing is that if you're setting up, or your clients are setting up, a revocable living trust, we call it a RLT, then they're going to fill all 3 of those roles. So let's say it's you setting up the trust. You are the trustor because you set it up. You're the trustee because you have full control. And you're the beneficiary. You can take out whatever you need. And it's also implied in the name, a revocable living trust. It's revocable, it's amendable. It's basically business as usual for you or your client. And so you can use all of your assets, or your clients can use all their assets just the same. It can be amended and revoked. But after somebody passes away, the trustor passes away, then the trust becomes irrevocable. So let's say it goes from the parents, and then after both parents pass away, goes to a daughter and son. Well, the trust created in the trust document for the daughter and son are going to be irrevocable trusts.
But that's not necessarily a bad thing. Irrevocable sounds like the kids aren't going to have control of it. But in fact, you can set up an irrevocable trust where the grown son and daughter have control over it. And the advantage of it being irrevocable is that it provides divorce protection and divorce protection, obviously in a marriage kind of problem. And it provides asset protection from lawsuit type creditors for the property inside that irrevocable trust. So you can create a trust so mom and dad can create a trust for their daughter that gives her control of the property, makes her the beneficiary. But in a divorce, the property inside the trust never picks up any community property character. And if the daughter gets sued under Texas law, the property inside that trust is not available to answer the lawsuit. So this is a terrific way to enhance the gift for grown and responsible children.
And then one last thing is that there's not going to be any change for income tax purposes. The trust is going to use one of the trustor's Social Security numbers, and so you'll just file your tax returns as usual. And so it's, again, business as usual. And so you might wonder yourself how the trust helps you with the closing the sale. Well, as I alluded to this earlier, it's that you're going to know if there's a trust exactly who you're going to be working with, and that they are going to have authority without going through a probate process that's going to hold you up. So let's say you sell a home to an elderly couple. You might want to recommend that they create a trust and title the home to the name of the trust. And the reason for that is, well, you got a pretty good idea that one of the two are going to become either disabled or deceased in the near future. And if, let's say, it's dad that passes away and now mom says, hey, this house is too big for just me, she wants to sell it or needs to sell it for nursing home needs, you're already going to know that if your hope, I would imagine, is that you're going to be the one to sell the house also. And because you want that continuing relationship with your clients. Well, this is just only going to facilitate that further relationship with your clients, because you're going to know who's got authority and that you're not going to get held up by these big delays. It's also the same is true with a living for disability or death, is that you're not going to have to go through the living probate or the death probate. And so that'll save your clients not just money, but also time. And that'll help you out in your process of getting the home sold. But I tell you what, families and clients will appreciate that you're knowledgeable on these things. It just shows that you're, a notch above. All right, so we're going to do a quick pop quiz. Bob, do you want to run this? I mean, it's pretty quick.
So, what are the three positions of a trust?
So we'll just run through these quickly. Of course, we've got trustor, a trustee, and beneficiary.
If the client has a trust, and can the trust be changed while the client is still living?
The answer is, well, if it's a revocable living trust, the answer is yes. If it's a trust that was set up by somebody else who passed away, then it's going to be irrevocable and they can't change it.
Can anyone change the terms of a client's trust after he or she is deceased?
Most likely not.
And this is, like I said, potentially this just creates advantages for your kids. And presumably the reason why you would set it up, why the parents would set it up that way to create a irrevocable trust for the kids, is specifically to provide additional benefits, control, protection for their children.
And we've got some slides. We'll go over some of those protections and benefits.
When a client with the trust dies, why is probate unnecessary? If the property is controlled by the trust, then the trust controls it. It says who gets it, and it says how it's who's going to be the trustee, and so it allows you to skip the probate process.
Mm-hmm. So you can imagine your clients are husband and wife, and when they title their assets in the name of the trust, let's say the husband passes away, well, the trust is still there. It just keeps on ticking and trucking through time. So there's not going to be a need for a death probate because the trust is still operational.
How soon after a client dies can his or her successor trustee sell the client's home? So remember, with probate, you got to get the letter from the judge. So it's going to be at least 8 weeks. With the trust, they should be able to sell the home as soon as they have a death certificate, probably in about 2 weeks.
And then, are there any other benefits to the trust? Absolutely. Bob alluded to some of them already, but we're going to run through some of them real quick. So some additional protections are that, here's a big one, for young and old, is that when one spouse passes away, if the surviving spouse gets remarried, that is just going to destroy any idea of estate plan that was already there, because the new spouse of the surviving spouse, if they live longer, there's a chance that they're going to inherit something that was left to the surviving spouse's children, who was, the son and daughter of the originally deceased spouse. And so assets can go all over the place, and then there can be fights. It can be a huge deal. So one thing we like to do is include provisions that protect against the danger of remarriage. And so it'll keep an estate plan going in the right direction without getting veered off course. Additionally, and Bob alluded to this earlier, let's say when your children or your client's children inherit the property, you can protect against divorce. Now, America has one of the highest divorce rates in the developed countries in the world. And so this is a huge protection that a lot of people are worried about, because they don't want to see their son-in-law or daughter-in-law, whom they may or may not like in the first place, walking away with, half of the money that they left for their kid. So that's a huge benefit. There are several other enhancements that can be done. And so, if you want to provide to your grandchildren or provide for specific purposes, or perhaps over a span of time, then that can be set up. With a will, it is the old-fashioned just divide, dump, and dissipate. Divide it up between the kids, dump it on them, on their laps, and watch it dissipate away. And then another huge benefit, and this is an area where you almost need a trust, is if there are beneficiaries who have special needs, especially if they're receiving any government benefits, is that you don't want to disqualify them for the benefits that they're already receiving or may receive in the future by providing them with money that would essentially make them fail a means testing.
Well, and let me add one other thing.
Yeah.
Anytime a person has little children, they have to, if they're going to do estate planning and take care of them, they have to create trusts, either have a living trust or create trusts in their will for those young children, because kids who are underage can't inherit property. And any parents, if they a single parent or a couple, if they think about their worst case scenario, they want to appoint guardians for the children, and they want to appoint a trustee to handle assets for that kid. And if you don't have that planning, if you don't have those trusts, then it's going to be nothing but a nightmare for your family in trying to take care of your young children. So this is just a crying need for decent estate planning for young couples that have young children, or for someone who's trying to take care of a special needs person.
Great point, Bob. And it also brings up another point, is that we've been talking about revocable living trusts that you or your clients can set up during lifetime. Another way of setting up a trust is including the language in the will document. It's called a testamentary trust. It has advantages, absolutely, but it does mean that a probate will be required to actually activate.
Yeah, it doesn't avoid probate, but it solves that other problem of the little kid inheriting money.
And then a painter's house is never painted. You can recommend these things and be aware of it for your clients, but I should have said it in the get-go. Think about yourself and how these issues relate to you and your personal circumstances. If you are part of a blended family, or don't have any planning, or have a special needs child, or maybe a beneficiary with, let's say, an addiction or spending issues, debt issues, you're going to want to take a look at your own situation and see if you're also, if this makes you uneasy when you think about your own situation, then you should probably give us a call to get some peace of mind so you can get something put in place.
Hey, did you know there was a probate judge in Harris County that died without a will?
Yeah.
Oh my goodness.
Exactly. Okay, so what do you want to do? Well, we recommend that you find an attorney that is the right fit for you. And, we hope, of course, that it's us and that you'll count on us to be your trusted advisor. But regardless, you need to find somebody who specializes in estate planning.
And is willing to talk to you about your clients when you have these issues come up.
Yes. And then we pride ourselves on our membership as members of the American Academy of Estate Planning Attorney. It's a fantastic organization for small estate planning law firms all across America. How many would you say there are? 150?
There's about 150 law firms across the United States that are affiliated with the American Academy.
And so with the American Academy, we are able to maintain best practices, both with our internal processes, with our client control, and also with our documents. They're
world-class documents.
You want to rely on an attorney that's going to offer free education. I know you guys had to pay $5 for this presentation. That was just a Trek rule, and we will be donating that money to the Houston Food Bank. But we do offer lots of free education. We're constantly doing classes. We have a large classroom set up across the hall where we can host classes and covering a variety of issues. Also, are they in it for the long haul? Bob kind of alluded earlier. I am a bit of the succession plan. And, Bob has so much experience and he is such just an irreplaceable resource. But I'm here for the long haul as well. And so sometimes youth can be frowned upon, or you think that there's a lack of experience, but youth is a great thing with estate planning attorneys because you want your estate planning attorney to be there for a long time, to address not only your needs, but your kids' needs and maybe even grandkids.
Well, and we have thousands of clients here in the Houston area. And that's another aspect of estate planning. It's an aspect of your business. When you do business, you're hoping that you've established a relationship and those clients will come back to you. And in the estate planning, it's even more important that our clients feel comfortable when we first begin to work with them, because they are going to need our assistance as time goes by. As time goes by, they are going to need to amend or update their plans, or they're going to have questions about their planning. And as life takes its toll, they need assistance. And I tell my clients now, I said, we're actually in the same boat. If something happens to me, my wife's going to go, what do I need to do now? Or if something happened to my wife and my kids are going to go, okay, what do we need to do now? And so there's a need to be able to come back to the people that you have confidence in, the businesses that you have confidence in. And what you want is somebody that's interested in the success of your estate plan or the success of your real estate sale, and that will give consistent advice over time. So we want to be that, and we'd like to help you assist your clients as well.
Absolutely. And to that same point, you want to find somebody like us we focus and pride ourselves on our relationships. That's really what we're in the business of, is developing these relationships. You'll find a lot of, of course, if you go online, you'll find documents available, but also other attorneys who, just aren't as focused on the relationship, are more about just pushing documents and doing transactions. That's not what we're about. We really do care about the success of our plans and of our clients. And then upfront and honest pricing. So we offer free consultations, and we do upfront pricing. So when you come in for a consultation, we'll evaluate what's going on and decide what needs to be done, and we'll provide a price right then and there for doing those documents. Bob's been doing this for 25 years now. I've been doing it for a couple of years. We know what it takes to get the job done right, and so we know what to charge. Additionally, if this is something, so this presentation, thank you very much, Lynn. We appreciate that you helped sponsor this, but if there's anybody out there who you think that your clients might benefit from hearing this presentation or any other presentation about estate planning, then please let us know. We host private events like this one, and many different professionals can use these events to market to their new and existing clients. So let us know if you want to give a presentation and, you know, what issues you really want to discuss in that presentation, and we'll see what we can do.
It's always, it's so tricky, this part. There are different questions that they all have to ask. And no, it seems like with probate and estate, there's never, every situation is different. So they always have a lot of different questions. But we appreciate you guys. This has been great. And we'll do this again in our new training room so that they can actually meet you in person.
That's fantastic. I'm looking forward to meeting all of you guys in person. I'm looking forward to this being over with.
Oh, all of us, definitely.
Thank you, Lynn.
Did you guys see down there in the Q&A? Can you see? Looks like there is maybe a question. I'm trying to see if I can pull.
Yeah, the question was, aren't ladybird deeds contestable by heirs for up to 4 years?
I would think, yeah, at least 4 years. So that's why the title company doesn't want to get into any contests, and that's why if there's a ladybird deed, they want it to. Typically, if there's a ladybird deed, there's not going to be a probate. I mean, typically those two things aren't going to go to necessarily go together. And so then the title company wants to know that all the intestate heirs are part of or receiving property from that ladybird deed, or if they're not, that the ones who didn't get it are okay with that. So they may have them do quitclaim deeds. So the title company is not going to get into a question. If they have a question about whether that ladybird deed is proper, they're not going to do the closing until they resolve it. They're going to resolve it at the time of the sale, or it's not going to happen.
There was one more question. What happens when the trust holds land but not the homestead? Should the homestead be in the trust when both husband and wife are still alive?
Well, okay, yes, and I kind of think I know what they're getting at. So let me answer it this way. The first thing to say is that putting the home into the trust does not prevent the family from getting their homestead exemption, and it also doesn't. If they sell the home out of it, it doesn't prevent them from getting their exemption from capital gain. So there's really no downside to putting the home into the trust. Furthermore, there's federal law that says even if the home has a mortgage on it, that putting it into the trust does not trigger the due on sale clause. So the short answer is putting it into the trust and holding the homestead in the trust is not a problem. And it is a help in avoiding probate and dealing with disability situations. But I think here's what's triggering your question. When people want to buy, want to refinance or mortgage a home that's in the trust, a lot of times the mortgage companies balk. They would prefer that the home was in the name of the borrowers rather than in the name of the trust. Now, this isn't really a problem, except that the mortgage company is part of their, if it's in a trust, they don't know how to put their clause into the client. But if it's a person, they know how to get their clause into you. But if it's a trust, they're not so sure. So you have to have an attorney opinion letter, or somebody's got to look at the trust document and make sure that the trustee is authorized and required to pay the mortgage. And so that little hitch is why a lot of the mortgage companies want the client to transfer the home out of the trust before they refinance it or whatever the transfer. That's why you have that idea that somehow it's an extra complication. I think that's where it comes up. But in other contexts, having it in the trust is not a problem at all, and it's a help. Hope that answers that.
All right. Now let's go.
Any other questions? Are we good there?
Well, at the end, we'll look and see if there's any more questions as they come in. And so I know this is a part that many of you guys are probably anxious to hear about is how do you get your CE credits? Well, you should have just recently received an email during this presentation. Mary, have you sent that out?
Yes, everyone should have just recently received an email that asks you to reply to it with the information that we need to fill in your CE credit. And if y'all could reply to those emails. Now, if you didn't receive an email, you can go on to the chat screen and we can figure out anyone who are missing.
Very good, thank you. And so, yes, just follow Mary's instructions there and reply to the email with all of the information that's needed. So step 2, this goes to the whole painter's house is never painted. Give us a call for a free consultation. If anything that you heard today either causes you anxiety or excitement, or you just are uncertain about whether your planning that you have or the lack of planning that you have is sufficient. And so this is just an hour-long conversation. Our consultations are about an hour to an hour and a half. And it's free, as we mentioned. And really what we'll do is we'll get to know your personal situation, and it will be personal. So it'll be a little more personal than what you want to discuss on a casual conversation. But that's necessary because we need to know what's going on so that we can build a plan specifically for you. And then once we've worked and developed a plan, what we do is we, again, do our upfront pricing and give you a schedule of what the process is going to be, and ask you a very simple question. Do you want to proceed with us today? It's either a yes or a no. If it's a yes, fantastic, we'll get started right away. If it's a no, then you know what? We will both be better off for having met each other, and we'll just know that this is something that's still on your to-do list. But the maybe is just too gray. It leaves it's not good for you because you don't really recognize it as still being on your to-do list. And we need a more clear definition of our relationship. And so please just give us a call if you'd like to schedule an appointment. We can do it over Zoom, Skype. We're also going to be opening up to more and more in-office presentations really starting next week. Consultations. And when you call, you can either set up an appointment now, or you can try to get something scheduled and on the books for later on, because we do fill up pretty quickly. Now, I didn't mention earlier, but this goes to saying everybody likes a bargain, and estate planning is not the place to look for a bargain. That's gas and, I don't know, kids' clothes maybe. But estate planning is more like a parachute or a fire extinguisher. You don't know if it's actually going to work until you need it. And when it needs to work, you need it to work right. And so, but what we want to do in terms of offering you a bargain is that we do appreciate that anybody who participates in our educational seminars. And so we want to offer you a $250 credit on any new trusts that are established. Now, this is referring to you, the viewers today, not necessarily your clients, but anybody on the presentation today will get a $250 credit or 5% off any other planning. And to receive the credit, please just call and schedule an appointment. Now, to use the credit, we do ask that if you're married, that both spouses attend the meeting, that you call and schedule the appointment promptly, and that at the end of the consultation, you do provide us a yes or no answer. There's that. I really already talked a little bit about what to expect, but we like to have clear, defined processes, and our consultations are no different. We'll sit you on time. We'll sit down with your clients promptly. And the first part of the meeting is learning about personal circumstances and finances. Second part of the meeting is where the client can ask questions of us and address any remaining questions they might have. And then thirdly, we're going to develop an estate plan and ask yes or no if you want to proceed or not. Pretty straightforward. All right. Well, guys, thank you so much for watching today. And